right to a fair trial. 1. In accordance to Article 6 of the European Convention on Human Rights. 1-1. In the determination of his civil rights and obligations or of any criminal charge against him, everyone is entitled to a fair and public hearing with a reasonable time by an independent and impartial tribunal established by law. Judgment shall be pronounced publicly, but the press and public may be excluded from all or part of the trial in the interest of morals, public order, or national security in a democratic society, where the interests of juveniles or the protection of the private life of the parties so require, or to the extent strictly necessary in the opinion of the court in special circumstances where publicity would prejudice the interests of justice. 1-2. Everyone charged with a criminal offense shall be presumed innocent until proved guilty according to law. 1-3. Everyone charged with a criminal offense has the following minimum rights. 1-A. To be informed promptly in a language which he understands and in detail of the nature and cause of the accusations against him. 1-B. To have adequate time and facilities for the preparation of his defense. 1-C. To defend himself in person or through legal assistance of his own choosing, or, if he has not sufficient means to pay for legal assistance, to be given it free when the interests of justice so require. 1-D. To examine or have examined witnesses against him, and to obtain the attendance and examination of witnesses on his behalf under the same conditions as witnesses against him. 1-E. To have the free assistance of an interpreter if he cannot understand or speak the language used in court. 1.1. In a democratic society, within the meaning of the Convention, the right to a fair administration of justice holds such a prominent place that a restrictive interpretation of Article 6, Section 1 would not correspond to the aim and the purpose of that provision. 1.2. Whereas, in cases concerning Article 8 of the Convention, the right to family life, Article 6 also applies to the administrative stages of the proceedings. Article 6 does not provide a right of appeal. This right is provided for in criminal cases in Article 2 of Protocol Number 7 to the Convention. 1.4. The character of the legislation which governs how the matter is to be determined, civil, commercial, administrative law, etc., and that of the authority which is invested with jurisdiction in the matter, ordinary court, administrative body, etc., are therefore of little consequence. 1.5. Whether or not a right is to be regarded as civil, within the meaning of this expression in the Convention, must be determined by reference to the substantive content and effects of the right, and not its legal classification under the domestic law of the state concerned. Subsection 1. Be it known, then, as part of this treaty, then, that any nation government conspirators who commit false arrest of any citizen or veteran who exercises his or her rights to freedom of press and freedom of speech, as was the case of U.S. Marine veteran of the Gulf War, Rob Law, who exercised the same herein on a website known as Facebook, to the extent they are not given the due process of law, read their rights, informed of the formal charges in accordance to their civil rights, detained in a mental facility or other type of holding facility and denied the right to a phone call for up to 5 or 6 hours, and later denied the right to face their accusers and be arraigned with a plea entered of guilty or not guilty, is the same as committing the crime of which the agents of said federal government of any nation would accuse the arrestee, in this case the U.S. Marine veteran of the Gulf War, being falsely accused later on to his mother in question that called the FBI in this case that his actions were terrorist in nature, of being the action of domestic terrorism, and furthermore, that any said agents who have committed the crime of which the arrest and accuse a veteran or civilian falsely be held liable for violating their code of ethics of their legal department, violation of 10 orders that they swore they would not follow, violation of the particular state of the Union's constitutional rights regarding extradition of the accused, and additionally, violation of the county sheriff's reserved rights of notification by gaining assistance of local city authorities, be charged for domestic terrorism and dishonorably dismissed from such federal agency of the government in that nation of question. Subsection 2. Furthermore, that if the city local authorities are also ordered by the federal agency of the government in any given nation, without due process of law served in writing, then they be held responsible for not contacting the county sheriff, state police, for verification of such orders of a federal agency, and they too are reprimanded for violation of the sworn oath of 10 orders they will not follow, violating the civil rights of a citizen or veteran of a foreign war by means of arresting said federal agency of a false arrest for exercising constitutional rights, be suspended for not less than 3 months. Subsection 3. And finally, that the state of the Union to which the citizen or veteran of that foreign war was not properly extradited by the constitutional rights granted to the elected governor of that state by means of notification shall then consider it a hostile terrorist attack and in violation of the constitutional rights to run the state as they see fit, as long as they are not in violation of that nation's federal laws, thus constituting a civil war by the federal government for sending said agents in the manner of which violates the elected governor's rights over his citizens that are under his or her protection of that particular state's own set laws. Civil rights or obligations. 2.1. In a simplified definition, as an opinion basis, the first and foremost objective in any given criminal trial for war crimes against the accused is to be decided as to whether the accused is to be charged for violation of civil rights or to be charged for violation of moral and legal political obligations. 2.2. Civil rights are defined as follows. 1. Rights to personal liberty established by the 13th and 14th Amendment to the U.S. Constitution and certain congressional acts, especially as applied to an individual or a minority group. 2. The rights to full legal, social, economic, and equality extended to blacks. 3. The same type of rights as are covered in the Articles of the Convention based as a whole to many nations in accordance to the Constitution of the United Nations. 2.3. Obligations as defined simply as 1. Something by which a person is bound or obliged to do certain things, and which raises out of a sense of duty or results from custom law, etc. 2. Something that is done or is to be done for such reasons to fulfill one's obligations. 3. A binding promise, contract, sense of duty, etc. 4. The act of binding or obliging oneself by a promise, contract, etc. 5. Law. A. An agreement enforceable by law, originally applied to promises under seal. B. A document containing such an agreement. C. A bond containing a penalty with a condition annexed for payment of money, performance of covenants, etc. Not civil rights and obligations. 3.1. In Mayoya versus France, the Grand Chamber held that proceedings resulting in a deportation order were not criminal, nor did they determine a civil right, even when the deportation order was imposed as a direct consequence of a criminal conviction. What is a criminal charge? 4.1. The meaning in itself is broken into two separate definitions, for a simpler understanding as they would appropriate to a war crime. Meaning of criminal, meaning of charge. 4.2a1. Meaning of criminal, whereas shall be defined as freedom of speech or freedom of expression, cannot be a criminal offense. Subsection 1. However, if the nature of the violation of the freedom of speech and expression exceeds the total victims of such at 50 plus, given a population or simple head count during said war crime, then it shall be counted as a misdemeanor charge. Subsection 2. Wherefore, for every group of 50 plus that were violated of their freedom of expression and speech shall count as an additional misdemeanor charge. Subsection 3. If the misdemeanors exceed 5 times the group counts at 50 plus, which would be 250 plus, then this becomes a state's felony charge. Subsection 4. After 3 times the state felony charge at 250 plus, which actually would be 750 plus, then this becomes a federal felony charge. Subsection 5. If after 3 times the federal felony charge at 750 plus, which would be 1500 plus, then it becomes the responsibility of the United Nations to place a warrant on that political leader's record and bring them in for a tribunal for violating the Geneva Convention, laws of war, and the UN Constitution. Subsection 6. If, on the other hand, it is discovered by reasonable reports, intel, or other means that the UN elected official has failed to carry out the duties for which they are elected, they shall be suspected as being tainted or corrupt, and thus aiding and or abetting of the war crimes committed against a particular nation's people. Wherefore, an order from the United Earth Federation Council shall charge the UN elected official as such and enter a vote of no confidence, to which a new UN chairman shall immediately be elected from any member nation to be the newly elected presiding official, and thus reinstate the warrant of that particular nation leader for committing a war crime as defined by this treaty and face a Geneva Convention trial, or may elect to allow the higher authority of the United Federation of Planets to exercise jurisdiction for violation and treason against humanity on a planetary legal scale, grander basis, for which carries a much greater penalty than even that of the treason charge found in any nation, including the United States of America. 4.2a2. Domestic classification. Subsection 1. If the contracting states were able at their discretion to classify an offense as disciplinary instead of criminal, or to prosecute the author of a mixed offense on the disciplinary rather than the criminal plane, the operation of the fundamental clause of Articles 6 and 7 would be subordinated to their sovereign will. A latitude extending thus far might lead to results incompatible with the purpose and object of the Convention. Subsection 2. Thus, in simpler layman's terms, domestic for a political leader of a nation shall be documented as within their own nation's boundaries and not spilling over into other countries, whether they be part of the country's precepts or not. As an example, Jamaica, Haiti, etc. 4.2a3. Nature of the offense. Subsection 1. Disciplinary sanctions are generally designed to ensure that the members of particular groups comply with the specific rules governing their conduct. Furthermore, in the great majority of the contracting states, disclosures of information about an investigation still pending constitutes an act incompatible with such rules and punishable under a variety of provisions. as persons who, above all others, are bound by the confidentiality of an investigation, judges, lawyers, and all those closely associated with the functioning of the courts are liable in such an event, independently of any criminal sanctions to disciplinary measures on account of their profession. The parties, on the other hand, only take part in the proceedings as people subject to the jurisdiction of the courts, and they therefore do not come within the disciplinary sphere of the judicial system. As Article 1, Section 85, however, potentially affects the whole population, the offense it defines, and to which it attaches a punitive sanction, is a criminal one for the purposes of the second criterion. Subsection 2, using simpler layman terms, it then becomes a necessary means to define nature of offense with some examples. Subsection 3, should this be the case, whereas any political leader's offenses fall into the category given as an example of subsection 2 above, then this makes the charges quite clear. 4.2a4. The purpose of the penalty, subsection 1. In simplified terms, as an opinion basis, the definition for the purpose of a given penalty shall be as follows: deterrence or public education, incapacitation, rehabilitation. The death penalty is among the oldest criminal punishments. It served three purposes: to punish a crime, to prevent its repetition, and to discourage crimes. The modern death penalty is imposed for similar reasons. However, the irreversible taking of a life is today considered abhorrent in criminal justice systems, notwithstanding the equally cruel prospect of life imprisonment. The basic objection to current death penalty laws are their inconsistent application, either by crime or by ethnicity. 4.2a5. The nature and severity of the penalty, subsection 1. Deprivation of liberty, as a penalty, generally makes a norm criminal rather than disciplinary. Subsection 2. Wherefore, in a society subscribing to the rule of law, there belong to the criminal sphere deprivation of liberty liable to be imposed as a punishment, except those which by their nature, duration, or manner of execution cannot be appreciably detrimental. The seriousness of what is at stake, the traditions of the contracting states, and the importance attached by the Convention to respect for the physical liberty of the person shall require that this should be so. Subsection 3. Thus, and in simpler terminology, the definition of said penalty being sentence will be defined as follows. The nature of the penalty is that by which the crime was committed. For example, in World War II, when Adolf Hitler was trying to impose a new world order, he started burning the Russians, which in turn, after attacking their cities, made the Russians switch to being our allies. Then, 95 to 98% of the time, the Nazis were burning Jews, gypsies, etc. in gas chambers, all for the New World Order. Thus, the nature of the penalty is the death penalty. Supposedly, Hitler committed suicide, but without a writ of habeas corpus at that time, and no body was found. There is no proof that Hitler did commit suicide, just as Jack the Ripper's body was never found or proven that he or it, evil entity that demonically possessed an individual to murdering women, had ever committed suicide by leaping off the London Bridge. The severity of the penalty. Depending on the retributivists, the crime level of severity might be determined by the amount of harm, unfair advantage, or moral imbalance the crime caused. 4.3a1. Meaning of charge. Whereas Article 6 guarantees a fair trial in the determination of a criminal charge against a person, and its guarantees apply from the moment a person is charged. Subsection 1. Wherefore, the official notification given to an individual by the competent authority of an allegation that he is suspected of having committed a criminal offense, or subsection 2, where the situation of the suspect has been substantially affected because of that same suspicion. What does the right to a public hearing entail? 5.1 Article 6 guarantees to everyone a public hearing in the determination of his civil rights and obligations or of any criminal charge against him. Article 6 further states that the press and public may be excluded from all or part of the trial in the interest of private life or of the parties require, or to the extent strictly necessary in the opinion of the court, in special circumstances where publicity would prejudice the interests of justice. 5.2 The public character of proceedings before the judicial bodies referred to in Article 6, Section 1 protects litigants against the administration of justice in secret with no public scrutiny. It is also one of the means whereby confidence in the courts, superior and inferior, can be maintained. By rendering the administration of justice visible, publicity contributes to the achievement of the aim of Article 6, Section 1, namely a fair trial, the guarantee of which is one of the fundamental principles of any democratic society within the meaning of the Convention. 5.3 Wherefore, admittedly, neither the letter nor the spirit of this provision prevents a person from waiving of his own free will, either expressly or tacitly, the entitlement to have his case heard in public. However, a waiver must be made in an unequivocal manner and must not run counter to any important public interest. What is meant by pronounced publicity? 6.1 Thus it is considers that in each case of the form of publicity to be given to the judgment under the domestic law of the respondent, state must be assessed in the light of the special features of the proceedings in question and by reference to the object and purpose of Article 6, Section 1. Number 4, the right to property. In 7.1, in the sense that certain information isn't available to be utilized with this treaty, then the definition of this international basis can be found and defined in the Constitution of the United Federation of Planets, pending all nation leaders' approval for said worldwide constitution. 7.2 The right therefore, and as defined by opinion, basis, shall be that no said property shall be taken without just cause and proof thereof, that said owner of the property was engaging or plotting to engage in an act of either terrorism or that of being a domestic terrorist, for which the terrorism by nature was to be committed by wrongful use of said property, other than what the said property is actually intended for, as resident citizen or guest within the nation that they have been established longer than 6 months to 1+ years. 7.3 Any government leader who sanctions by order to give an authorities or branches of the military to seize said property as a plot or plan of action to prevent said citizen from fleeing as a refugee from oppression and crimes being committed against the people for future dictatorship in the realms of evil ploys like that of World War II Nazi regime or a New World Order, or something sinister and evil in the equivalency thereof, shall be sentenced for the theft and value by which the government will be occupied, till such time the government replaces to the survivors of the victim of said war crimes, or the survivor upon rescue of the UN or authorized international allied forces, the value of said illegally seized property.
I start from the supposition that the world is topsy-turvy, that things are all wrong, that the wrong people are in jail and the wrong people are out of jail, that the wrong people are in power and the wrong people are out of power, that the wealth is distributed in this country and the world in such a way as not simply to require small reform, but to require a drastic reallocation of wealth. I start from the supposition that we don't have to say too much about this, because all we have to do is think about the state of the world today and realize that things are all upside down. Now, if you don't think, if you just listen to TV and read scholarly things, you actually begin to think that things are not so bad, or that just little things are wrong. But you have to get a little detached and then come back and look at the world, and you are horrified. So we have to start from that supposition that things are really topsy-turvy. And our topic is topsy-turvy, civil disobedience. Now, as soon as you say the topic is civil disobedience, you're saying our problem is civil disobedience. That is not our problem. Our problem is civil obedience. Our problem is the numbers of people all over the world who have obeyed the dictates of the leaders of their government and have gone to war. And millions have been killed because of this obedience. We recognize this for Nazi Germany. We know that the problem there was obedience, that the people obeyed Hitler. People obeyed. That was wrong. They should have challenged, and they should have resisted. And if we were only there, we would have showed them. Even in Stalin's Russia, we can understand that. People are obedient. All these herd-like people. Remember those bad old days when people were exploited by feudalism? Everything was terrible in the Middle Ages. But now we have Western civilization, the rule of law. The rule of law has regularized and maximized the injustice that existed before the rule of law. That is what the rule of law has done. When in all the nations of the world, the rule of law is the darling of the leaders and the plague of the people, we ought to begin to recognize this. We have to transcend these national boundaries in our thinking. Nixon and Brezhnev have much more in common with one another than we have with Nixon. J. Edgar Hoover has far more in common with the head of the Soviet secret police than he has with us. It's the international dedication to law and order that binds the leaders of all countries in a comradely bond. That's why we're always so surprised when they get together. They smile, they shake hands, they smoke cigars. They really like one another, no matter what they say. What we are trying to do, I assume, is really to get back to the principles and aims and spirit of the Declaration of Independence. This spirit is resistance to illegitimate authority and to forces that deprive people of their life and liberty and right to pursue happiness. And therefore, under these conditions, it urges the right to alter or abolish their current form of government, and the stress had been on abolish. But to establish the principles of the Declaration of Independence, we're going to need to go outside the law, to stop obeying the laws that demand killing or that allocate wealth the way it's been done, or that put people in jail for petty technical offenses and keep other people out of jail for enormous crimes. My hope is that this kind of spirit will take place not just in this country, but in other countries, because they all need it. People in all countries need the spirit of disobedience to the state, which is not a metaphysical thing, but a thing of force and wealth. And we need a kind of declaration of interdependence among people in all countries of the world who are striving for the same thing.